This week in U.S. immigration news, we are going to cover April 2023 Visa Bulletin Change Number 1, USCIS ends COVID-related flexibilities, temporary final rule extends certain employment authorization cards by up to 540 days, receipt notice delays at Vermont Service Center. April 2023 Visa Bulletin Change Number 2, some immigration judges delay your work permit, CBP terminates negative COVID-19 test requirement for passengers from China, Hong Kong, and Macau. DOS posted the April 2023 Visa Bulletin. Alert: the F2A category that includes spouses and children of permanent residents as beneficiaries is no longer current for April 2023. This means if you have a spouse or child you are applying for, then you need to file the I-130 before the end of March to attempt to preserve ability to file for adjustment of status. USCIS first announced a flexibility deadline extension in March 2020 to address the COVID-19 pandemic, but it now ended on March 23, 2023. This means if you received a RFE or Notice of Intent to Deny or Notice of Intent to Revoke after March 23, 2023, then you can only rely on the deadline in the notice. If you received a RFE or Notice of Intent to Deny or Notice of Intent to Revoke before March 23, 2023, then you have additional 60 days to reply to USCIS. Call Ting Law Group as soon as possible for guidance. Foreign nationals are experiencing gaps in employment authorization due to significant processing delays for Forms I-765, application for employment authorization, despite a 180-day automatic extension for individuals applying for an extension of their employment authorization in specific immigration category. Because USCIS case processing delays have continued to grow, USCIS has now announced that the automatic extension period will be increased from 180 days to 540 days. The temporary final rule was effective upon publication in the Federal Register on May 4, 2022. To be eligible for the 540-day automatic extension, you need to meet certain rules. Contact Ting Law Group for the link. USCIS has acknowledged that, due to filing volumes and intake delays, they are experiencing delays in the issuance of Forms I-797C. USCIS SCOPS anticipates improvements in timeliness for fee receipting and data entry functions within the next 30 days for business immigration filings. USCIS states to please allow for additional time for your receipt notice to be generated. USCIS determined that for April 2023, applicants in all family-sponsored preference categories must use the dates for filing chart and applicants in all employment-based preference categories must use the final action dates chart. This helps you to know when to file for adjustment of status I-485 form if you are eligible to apply. There have been reports that some immigration judges are continuing to ask asylum applicants at master calendar hearings if they wanted an expedited trial date, and if the applicant refused, the clock for asylum-based employment authorization documents was stopped. This means more delay for you to apply for work permit. As of December 4, 2020, EOIR's policy has been that immigration judges will no longer inquire as to whether a non-citizen wants an expedited asylum hearing date for purposes of the EAD clock. CDC announced the termination of negative COVID-19 test results from air passengers originating from the People's Republic of China, Hong Kong, and Macau, including those transiting through South Korea, Toronto, and Vancouver locations. CBP issued guidance supporting this termination.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our CARES team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.